You might have seen recently that 3D printable design files are appearing online again in plain view, but the feds are throwing a fit. So what's behind all this? What does the law say is forbidden, and how are the feds cocking it up? Let's talk about it.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
There's been a fight waging on for some time now. First the Fed against the gun printers, then the states against the feds, and now back to the normal Tom and Jerry deal. This is a hell of a story, and right now it ends with Washington v. Department of State. Let's take a step back here. What the hell is all of this about? Well, it all starts with this stupid punk Cold War era law called the Arms Export Control Act of 1976. The AECA lets the President of the United States control the import and export of defense articles. It was signed by Gerald Ford in June of '76. It requires foreign governments who receive arms from the U.S. to certify that the arms would only be used for legitimate self-defense. You know, the thing we're known so well for in the international community. So you might be thinking, well, what the heck does this have to do with me? I'm not sending anything abroad. Well, because we're governed by a class of insane, power-hungry demons. The thing is, the AECA is implemented through regulations promulgated by the executive branch, a source of problems we've grappled with more than once here on this channel. Get ready for a whole host of alphabet soup, because here come the acronyms. The AECA set up the International Traffic in Arms Regulations, or ITAR. This references the United States Munition List, or USML. The USML covers all things considered significant military equipment, SME, or arms subject to ITAR. Remember, this was set up chiefly to, keep you from sending plans to build a nuke to, Iran or whatever. The USML has for some time referred to weapons and related technical data. This hung around for quite some time without issue, clearly start targeting stuff like nuke plans and, chemical warfare stuff, right? Well, come 2013, 3D printing of gun becomes a bit of a cause du jour. A certain heavily untested single-shot pistol known as the Liberator took the news media by storm. This was in the Obama era, and the people behind this pistol had a heavy crypto-anarchist vibe about them. The Obama administration didn't want to be poked in the eye like this, so they did what every presidential administration has done for the last few decades: abuse the administrative agencies. In 2013, the Department of State went after the group behind the Liberator, claiming that the printable files were technical data controlled by ITAR, directing the company to remove them from its website. The argument here is that by simply having the files available to download, it constitutes an export, because, a foreign person could download the files. I know, it's stupid, but that was their game. So they took the files off the site, but it was too late. The file was everywhere, and as we all know, you can't stop the signal. 2 years later, in 2015, the company behind the Liberator filed a lawsuit against the Department of State, making First, Second, and Fifth Amendment claims. The argument, among other things, were that the design files of 3D printable guns were First Amendment protected expression, something I really agree with. After all, the court has repeatedly held that even functional articles can include artistic expression protected by the First Amendment. Things like inlays, aesthetic design choices, and more are comparable to sculpture. Plus, code has been held to be a form of expressive conduct as well. The argument is that the feds can't just arbitrarily take actions to restrict First Amendment conduct of Americans just because of a vague invocation of national security. But this case was filed back in 2015, so you might be wondering why and how it's relevant to the current situation. Well, the rabbit hole goes deeper. Near the outset of that case, the plaintiffs moved for a preliminary injunction to keep the government from exerting control over these files. The thing to understand here is that preliminary injunctions are preliminary. They happen before the actual case is litigated. The district court denied this motion, and it was appealed to the Fifth Circuit. The Fifth Circuit then denied it in 2016, and the ruling was appealed to the Supreme Court in 2017. In January of 2018, The Supreme Court declined to hear the case. Now, this doesn't mean the case was over. That means the case was headed back to the district court to finally proceed. That's when the State Department realized they were in over their head and offered to settle the case. This came in the form of the plaintiffs being allowed to publish their files, along with $40,000. When asked why State offered to settle, a spokeswoman said, "We were informed that we would have lost this case in court based on First Amendment grounds. DOJ suggested that State settle the case, and so that is what was done." Not wanting to deal with this mess and feeling a First Amendment loss in the future, State and Commerce would work together to make some long overdue changes to ITAR. They basically moved to take all ordinary firearms and their technical data out of the control of State and into the control of the Department of Commerce. You might be thinking, well, hell, I mean, they're still controlled, right? So, what's the difference? Well, there's a couple things at play here. For one, Commerce doesn't pretend to be the sole and exclusive safeguard of national security, desiring to examine everything with a microscope. Commerce is more interested in American companies making money than pretending to be superheroes. It kind of follows that we shouldn't have the same nerds deciding stuff about agents of biochemical warfare and, a semi-automatic rifle. Well, kind of follows. Second, and most importantly, is Commerce's definition of what kinds of technical data is subject to its jurisdiction. The definition excludes unclassified technology and software that has been published in certain terms that we'll talk about later. This makes a lot of sense, as why would the government be fussing over licensing information that's freely and openly available? Now comes the rub, though. The definition explicitly states that some files remain subject to the Export Administration Regulations, AAR, specifically CAM software that is ready for insertion into a CNC machine, including a 3D printer. CAM software, by the way, is computer-aided manufacturing. The examples they use for CAM software are AMF and G-code, which are basically a set of instructions tailored to a specific machine. The rub here, though, is the STL files. STL files are by far the most common one in the 3D printing sphere. It's the ones we all know and love. It's what you download, feed to your slicer, and get your, part in the end. In the write-up that attended this new definition, STL files were conspicuously absent, both from their explanation of design files, which are exempt, and from manufacturing files, which are still covered. STLs, in my opinion, are assuredly design files since they contain no machine instructions. It's just a 3D mesh of the part, basically a computer sculpture. The hang-up, though, is the STL file format, that being stereolithography, was designed explicitly for 3D printing, and it actually is ready for insertion into some 3D printers, which then do the slicing and generate ordinary G-code on the machine. Because of this, the current theory is that other common file formats, such as STP, which were mentioned in the rule, should be good to go if they are published. So, when word broke that a settlement was in the works, again, because the government literally was of the opinion its current policy violated the First Amendment, a group of state attorneys general got together to save the day. That's right, a whole host of them banded together to say, "No, feds, you must continue this lawsuit and violate the people's First Amendment rights." Seriously, they argued that because they were so scared of these ghost blasters, it posed a huge risk, and that the government shouldn't be allowed to settle their case regardless of the impending First Amendment loss. The attorneys general brought this case in the Ninth Circuit in 2018, along with a bunch of other federal circuits they thought might be friendly. Of course, they managed to secure an injunction against the federal government, with a judge agreeing that ghosts is spooky indeed. This injunction was appealed to the Ninth Circuit, who vacated the injunction, arguing that a certain law from the 1980s actually prevented the courts from stepping in on an executive determination on what is and is not on the USML. That should give you pause. It's actually terrifying. In light of all this, the company behind the Liberator decided to put up all of their design files online for unlimited distribution, except the STL files, which were behind a paywall. Shortly thereafter, the government issued a cease and desist, arguing, somewhat ineptly, that the stay which the court just vacated was actually still in place. Despite, of course, the regulations being published in the Federal Register, which now made this clearly allowable. This seems to me like the government is trying to buy time so they can jam something else through the Federal Register and put things back. I would normally say this isn't going to look good to the courts, but remember what we said earlier. Yeah, that court just brought up an act of Congress which prohibits the court from reviewing inclusion or exclusion of items on the USML. Theoretically, it shouldn't work what I think they might try to do, but I'm sure the Ninth Circuit will be chomping at the bit to disagree with me, as they've consistently done with a great many of our fundamental rights before. I cannot stress this enough. This is an important battle. There will likely be a proposed rule change coming down the pipe, and it will need to be resisted as passionately and informedly as we can. So right now, the state of affairs. Ordinary Title I firearms, that being non-automatic and semi-automatic weapons up to 50 cal, are off of ITAR and their technical data. You still need to work with Commerce to import or export those weapons, or to import or export the technical data, unless it is design data that has been published. Published files are those available without restrictions, libraries or public collections open to the public, stuff that was distributed at a conference or trade show in an unlimited fashion, unlimited public dissemination in any form, etc. So that's most of these files. Again, and just an aside, if y'all haven't gotten into 3D printing yet, come on, man. Affiliate link down below. Get your printer. It's really not expensive. That's it for today. Let me just say I really appreciate you guys watching and subscribing. It makes a huge difference. If you want to support me more than that, I started up a Patreon and Subscribestar. I've added benefits like a patron-only podcast, a Discord, and there's surely more to come. This kind of support will help enable me to make more content more regularly, something I'd really love to be able to do. There's also a link to the Fuddbusters sticker and the Magic ATF ball in the description below. Thank you all so much for watching to the end and for your support. I'll see you next time. Or if you become a patron or Subscribestar, I'll see you on the Discord. Remember, the anti-side has been working long and hard passing laws and trying to make more. Anything more than minimum compliance is self-regulation. Y'all take care.